Welcome back, everybody. This is Vital Descent. I'm your host, as always, Patrick McFarlane. This one is episode 266. The show notes may be found at vitaldescent.com/266. And in this episode, I am going to teach you all about South Africa's genocide case against Israel at The Hague and the International Court of Justice. We're going to be talking all about that. What is the court? What does it mean? And I know we tend to always be talking about genocide on this channel. I assure you that's not on purpose per se. However, I think that I have some unique insight that I can provide you guys. Being a trial attorney myself, I can peer past the veil, the secrecy, the special clique of evil lawyers talking about people being killed on the international stage, and maybe we can make some sense of it and put it all in its proper context and place. Do a little bit of analysis and hopefully understand the world a little bit better. I'm just going to talk for a little bit about, I haven't had an episode that I've released since October. That isn't for lack of trying. I actually had recorded an episode, found some time to record an episode, and then went back and realized that the audio was all echoey and really, really bad. So I couldn't release it. And that was just a killer for me. But it's been a really, really difficult, busy last 6 months. My third son was born in July, and last year was just a really big year for us. You know, we had a third child, we bought a vehicle, we remodeled our house. There was some other stuff that happened that I'm just not thinking of right now. But then, big holiday season, which is really difficult when you're a parent and you have kids, so many kids. And then we went and traveled for the holidays, and we all came down with influenza A, which is the worst strain of the flu, as far as I understand. So it's been really, really difficult. Thanks for bearing with me. I know that this show's been around for 7 years now. So people who have been in for the long haul are in for the long haul. So I won't say too much more about that. Let's dive right in. So as you guys know, on October 7th, there was a Hamas attack. I think I talked about it once in the last episode. Yeah, so 2 episodes. We've talked about it a little bit here on the show. We talked about how Palestine became Israel and going back for that, tracing the history of the conflict in terms of who rightfully owns the land. What is the operant libertarian question? Who is the rightful owner of the land? So we dove deep into that in /264, vitaldescent.com/264, the show. Then we talked about Israel's Jeffrey Epstein, which a lot of people said, well, isn't that just Jeffrey Epstein? Touche. I think that's funny. 265, we had our friend Brad Pierce on the show to discuss his article, but this had to do with a lot of the reports on the ground from October 7th arriving to us from an aid organization whose founding figure is kind of a Jeffrey Epstein of himself with scandal and things like that. So that was really interesting. But now South Africa has been the lone country that has come forward and has decided to undertake an accusation in the ICJ, the International Court of Justice, against Israel for genocide, an ongoing genocide. And we have talked about the ICJ before on this channel, in this podcast. We last discussed it in depth on December 2nd, 2022. So over a year ago, we talked about how Dave Smith was right about the Uyghurs when on Part of the Problem, he said that there's a lot of sketchy stuff with the reports of the Uyghur genocide, the alleged Uyghur genocide. And you might ask, well, Patrick, you denied that a genocide was taking place against the Uyghurs, and now you're going to come in front of us and you're going to say, well, it looks like there's a strong case that Israel is committing genocide against the Palestinians. But throughout this episode, we're going to see that, at least on a quantitative and a qualitative stance, South Africa has a much stronger case of accusing Israel of genocide than the international community does China for the Uyghurs. And we're going to get into why those two things are different. So I think this is going to be quite a long episode. Oh, by the way, the episode number on the one I was just talking about with Dave Smith and the Uyghurs, 239. So /239. So this is going to be a bit of a longer episode. I know that's just kind of how things are on this channel. We don't just talk about headlines. We dive beneath the headlines and do deep dives into these types of things. So I should mention that the Vital Dissent is a part of the Libertarian Institute and is featured there at libertarianinstitute.org. I'm the Justin Raimondo Fellow there. We just had a fundraiser where we were shouted out on part of the problem, and we successfully concluded that fundraiser with your help. So head on over there at libertarianinstitute.org, and you can find Vital Dissent in the sidebar there. So what is the ICJ, and what do they do? We're going to start at the very beginning here at the International Court of Justice, their website, icj-cij.org, how the court works. And then we're just not going to look at theirs because it's longer. But we're going to find this one article I was reading that I, of course, can't find right now at the moment I need it. Okay, here it is. This is an article at the American Society of International Law. What does the ICJ decision on the Gambia versus Myanmar mean? So this is a comparative case that we're going to use to compare to the application currently before the court, South Africa accusing Israel. But here's a nice primer. So we're going to use this Gambia-Myanmar case a couple times. But so it says, what is the International Court of Justice and what does it do? So the ICJ, also known as the World Court, was created by Article XIV of the UN Charter in 1945. It is located in The Hague, the capital of the Netherlands, and it is specifically designed to handle disputes between nations, or otherwise known as states, of course, but we know that. The ICJ provides a forum for states to bring their disputes to be settled peacefully rather than through conflict. A legal finding against a state by the ICJ usually indicates that the court believes that the state in question violated international law in some way. The ICJ is sometimes confused with the International Criminal Court, the ICC. Now, this is important because a lot of these cases kind of dovetail a little bit. The ICC is also located in The Hague. The ICC adjudicates individual criminal legal responsibility. States' leaders, foreign ministers, or other senior government officials may be put on trial at the ICC, but never at the ICJ. So remember that, is that the ICJ deals with states as large entities, and the ICC deals with individuals in those states. Now, the current application, we're going to take a look at the conclusion, because last week on Thursday and Friday, on Thursday, South Africa had their remarks on what you might be able to call like a preliminary injunction, if anyone has ever heard of that before. It's as a case is ongoing, since it's going to take a long time for us to get to the bottom of the dispute, this case is still ongoing and we're in the early stages of it, and there's irreparable harm. South Africa is alleging that Israel is committing irreparable harm that has to be stopped right now while the case is still ongoing. And that's really important. So the court is saying essentially, well, we can't figure this out right now. It's going to take too long, just logistically speaking. We're going to have this preliminary thing because people are dying right now. People are dying. And we're going to have, or at least South Africa is alleging that people are dying, but I think it's undisputed that people are dying. We're going to have a hearing on whether or not we should have a preliminary ruling that will preserve the status quo. Well, not really preserve the status quo, sorry, prevent the harm, that will seek to stop or prevent the harm while the case is being litigated. So that's what it is. The application of the Convention on the Prevention and Punishment of Genocide in the Gaza Strip. It's a request for the indication of provisional measures. So in lawyer speak, that's what I was talking about. Let's prevent the harm, take provisional measures to stop the harm while we figure out what's going on and get to the bottom of adjudicating this case. So it says South Africa admitted submitted a request for these provisional measures in a public hearing. The court has heard from both parties These are all the people. The court is now beginning its deliberation on the provisional measures, and a decision will be delivered at a public sitting, the date of which will be announced in due course, right? Okay, so they're going to think about it. They're going to issue a decision in like 3 weeks to a month, maybe a little bit longer. So these are the final requests of the parties after the 2 hearings. So South Africa, now they established jurisdiction, right? So it's an international court. There's no, so you could say, as Murray Rothbard said, that the countries of the world actually do exist in a state of anarchy in relation to each other, right? There's no one world government that is going to hear disputes between states and issue a binding decision that's going to be enforceable by a rule of law that's super national, that covers the entire world. So international law is all based upon a foundation of anarchy, which in a sense is voluntary assent of the nations to be governed under a set of rules. So the jurisdiction of the court, because the court is created by all these countries coming together and saying, hey, we're going to form an international court, right? And we're all going to sign this treaty, this convention on the prevention and punishment of the crime of genocide. South Africa is a signatory, and Israel is also a signatory. Israel constantly bringing up the fact that, in 1940, in the 1940s and the late 1930s, there was a genocide. You might have heard of it. It was called the Holocaust. And therefore, they created this convention on genocide to prevent that crime. Now Israel is saying, well, we are the OG genocide victims. So it is their assent, though, to that treaty that means that they are at the mercy of the court, that they have submitted themselves to the jurisdiction of the court. We'll get in some other, later on in this episode, we'll get into some other specific jurisdictional objections that Israel has and has made, and talk about that a little bit. But anyway, South Africa is requesting the court, as a matter of extreme urgency, pending the court's determination of this case on the merits. So while the court is hearing the rest of the case, like I said, to indicate the following provisional measures in relation to the Palestinian people as a group protected by the Genocide Convention. These measures are directly linked to the rights that form the subject matter of South Africa's dispute with Israel. 1, Israel needs to stop its military operation in Gaza. 2, Israel shall ensure that any military or irregulars, like the settler groups that they've been giving weapons to evict Palestinians living in Israel, ensure that any military or irregularly armed units under the banner of Israel or supported or influenced by Israel take no steps in furtherance of military operations in the Gaza Strip or in Israel against the people of Gaza. Sorry, I still have a pretty bad cough, so I'm going to try and keep that out of the audio. Now, 3, the Republic of South Africa and the State of Israel shall each, in accordance with their obligations under the convention, shall take all reasonable measures within their power to prevent genocide against the people of Palestine. 4, the State of Israel shall, in accordance with its obligations, stop killing members of the Palestinian group, stop causing serious bodily or mental harm to the members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group, which South Africa did try to make the case that Israel was doing that. Now that's the entirety of genocide allegations against China rests upon letter D, element D. 5, the state of South Africa requests the state of Israel shall desist from and take all measures to prevent the expulsion and forced displacement of Palestinians from their homes, depriving Palestinians of access to food and water, humanitarian assistance, fuel, shelter, clothes, hygiene and sanitation, medical supplies and assistance, and to cease the destruction of Palestinian life in Gaza. And Israel shall, in relation to Palestinians, ensure that its military not commit those acts or engage in direct and public incitement to genocide, conspiracy to commit genocide, attempt to commit it, or complicity, or be complicit in it. And also asking the court to direct Israel to preserve all evidence of their commissions of genocide. And for Israel to command Israel to submit a report on all measures taken to give effect to that order, and refraining from any action to aggravate or extend the dispute before the court or make it difficult to resolve. So to just be a difficult litigation partner, adversary rather. So for Israel, they just want the court to reject the request by South Africa and remove this case from the general list. So that's what they want. Now there's a short history of proceedings. I kind of covered that already. On December 29th, South Africa filed their application instituting proceedings against Israel concerning alleged violations by Israel of its obligations under the Convention to Prevent Genocide. And they requested a declaration of provisional measures, and that their request for provisional measures to be granted have priority over all other cases, which expedites the entire process. So let's take a look at the actual Genocide Convention itself. Now, I've covered this in other episodes, so I'll just try and be brief. So Article 2 is the main article. These are any of these acts committed constitute genocide when they're committed with intent to destroy in whole or in part a national, ethnic, racial, or religious group. So that's called the mens rea. Mens rea in criminal law is basically the guilty mind, the guilty conscience. So it's doing something with the intent. It's kind of like the intent element, and that's pretty important. And as we'll talk about a little bit later, in Israel's defense, if we're going to play devil's advocate, trying to be the most effective advocate that you can be, you need to be able to evaluate both sides of the argument for strengths and weaknesses. If I were defending Israel in this, I would go after the intent element for the most part. I mean, make your jurisdictional arguments, but also attack that intent. So, but any of these actions, A, killing members of the group, B, causing serious bodily or mental harm to members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, D, imposing measures intended to prevent births within the group, E, forcibly transferring children of the group to another group. And that's all of Article 2. So Article 3 says, the following acts shall be punishable: A, genocide; B, conspiracy to commit the same; C, direct and public incitement to commit genocide; D, attempt to commit genocide; or E, complicity in genocide. So I think that, Article 2B, causing serious bodily or mental harm to members of the group, I think that's kind of broad and vague. Maybe that needs to be more well-defined with case law, and I'm sure that case law exists. And again, it has to be combined with that intent to destroy in whole or in part. So maybe that narrows it down a little bit just from my picky kind of thoughts. Article 4 says persons committing genocide or any of the other acts enumerated in Article 3 shall be punished, whether they are constitutionally responsible rulers, public officials, or private individuals. Article 5, the contracting parties undertake to act in accordance with their respective constitutions, the necessary legislation to give effect these provisions. So the persons charged shall be tried by a competent tribunal in the state, of the state in the territory of which the act was committed, or by such international penal tribunal as may have jurisdiction. So maybe the ICC. So Article 7 says genocide and the other acts enumerated in Article 3 shall not be considered as political crimes for the purpose of extradition. The contracting parties pledge themselves in such cases to grant extradition in accordance with their laws. Any contracting party may call upon the competent organs of the UN to take such action under the Charter as they consider appropriate for the prevention and suppression of acts of genocide or any of the other acts, disputes shall be submitted to the International Court of Justice at the request. So that's what South Africa did under Article 9. Yeah. So there's a bunch more. I don't think it's quite as applicable to this case, so I'm not going to go through them, but I'll put a link in the show notes page so you guys can review the entire treaty. So I think it's important. So now we know what genocide is. We know what the court is and how the court works, and what happened with South Africa. I think one of the big questions is, okay, say that South Africa wins and they get their provisional measures, right? What's going to happen then? Well, the case is going to keep going, right? And more evidence will be collected, and there will be a final determination at a later date, probably years from now. And I think that, let's see, we saw that there was a case where, sorry, I'm flipping through all my tabs here for the video version. There was a case, a recent example, just 4 years ago now in 2020, where the provisional matters were found, right, in this the Gambia versus Myanmar case. Now, I think that was, Gambia was, I think the party that was, if we take a look at how it's titled here, South Africa versus Israel. Yeah. So Gambia was the country that was prosecuting the case for genocide, right? They were the prosecutors, like the district attorneys that we would have here. And Myanmar was the country being accused of committing genocide. But what happened there, right? Because provisional measures were found, and the court did institute those provisional measures. So I'll just go through here. What are provisional measures and what do they do? Provisional measures serve as the equivalent of injunctions or even temporary restraining orders against a country. They are requested when one state believes that there is an ongoing legal violation from which it will continue to suffer some harm while the court considers the underlying claims. In this case, the Gambia fears further harm to the Rohingya population. There are very specific circumstances in which provisional measures may be authorized by the court. Essentially, these relate to the court's jurisdiction over the parties and the issue, which is called prima facie jurisdiction. Whether there is arguably a link between the rights asserted, which the court must determine are plausible, and the requested preliminary measures and the urgency and scope of the potential harm. So the Gambia asked for similar provisional measures as in this case. They filed it in front of the court. There was oral hearings held soon after, and the ICJ issued its order on January 23rd, 2020. After the original hearings, the oral hearings were held on December 10th. So that's about, a little over a month. Right now, we're between their December 10th date and the January 23rd date. So it goes through the specifics of that case, which we're going to skip. But now we'll go to this question of, okay, say that South Africa wins. Now what? The ICJ has released the schedule for both sides to submit their legal briefs addressing the issues on the merits that are in dispute. The Gambia must submit its written memorial. So both sides will issue more briefing if South Africa wins, but there will be further briefing. The case will continue, right? Then the ICJ statute will require that the order for provisional measures be transmitted to the UN Security Council for review. The UN Security General will basically review the provisional measures, the declaration, and issue a statement, as he did in this case, the Gambia case, in Myanmar case, taking official notice of the ruling and expressing that he trusts Myanmar will duly comply, right? Well, what does it mean if, so in this case, there's a question, is there any way to ensure that Myanmar complies with the court's order, right? Because it's voluntary, it's a convention voluntarily assented to by the member countries. No, there is no way to ensure that they comply with the court order. So there is no way to ensure that Israel would comply with the declaration of provisional measures. And that is the concern of many non-governmental organizations and governments who know that compliance with international law relies in large part on the cooperation of the concerned states. And Benjamin Netanyahu said after the remarks on Thursday and Friday, he said that no one will stop us in our mission, not even the Hague, which is like not a very good quote to have attributed to you or for you to say. Not even the Hague will stop what we're doing here today. Just not really a good look. I mean, it doesn't necessarily mean much of anything, but it's just not a quote that you want in the historical record for you. So the Myanmar civilian government's press response to the order did not engender confidence that it was going to comply with the requirements set out. So we'll see what happened. Or excuse me, what will happen with Israel if provisional measures are granted. So now that we understand what the court is, what it does, what the history of this proceeding is, how it's going forward, I think we're just going to jump right into... Now, I didn't get a chance to watch all of it because there's 3 hours for South Africa's opening remarks, and there's also 3 hours for Israel's response. And I watched maybe the first 25 minutes of South Africa's initial remarks. And the important one, and the one that this lady is going to come up here, and you've probably seen this because her clips have been the ones that have been kind of all over the news cycle, right? I don't know her name particularly just offhand, but she made the remarks and she said, well, these are the acts that we consider to be genocidal in our case, and that we're going to present to the court as being the genocidal acts. Now, this is very different than like a jury trial in the United States. In fact, it's not even a trial at all. And I think that in a trial that we have in the United States, you see a lot of them being broadcast on court TV and stuff like that, which is really incredibly interesting to watch. And I think in a way we're kind of lucky that we have that available to us, that there would be the news, that journalists would be allowed to broadcast jury trials in their entirety. One, because they're incredibly entertaining. Two, because in a democracy, it's really important to have transparency for the public to be able to see these proceedings and try to understand them and in a way participate in it. But you also run a risk of, in that sense, the same dangers that you have as a democracy. And I know we're not a democracy. We're supposed to be a republic, right? There's that whole meme that's kind of been going around. And when in fact we're like, people will say, well, actually we're a dying empire, right? Whatever it is, the danger of having, public scrutiny is that the public doesn't really understand what they're seeing all the time. And I've seen some commentators, just lay people commentating. And of course, I am a practicing attorney, and these folks you'll see on screen are all practicing attorneys that have had long, distinguished legal careers. They're arguing their case in a tribunal that they probably don't usually practice in. I could be wrong about that, but they have talked about how these legal advocates, sure, they practice maybe international law, but they practice in their individual jurisdictions that they're hailing from. But I would caution everyone to try not to jump to judgments, because I don't like armchair, as an attorney, I don't like armchair these people that have true crime channels and they go in and they order police reports, the ones that are open to public record. I just saw this on Lore Lodge. It's a YouTube channel called Lore Lodge, where this guy who ostensibly doesn't have any kind of legal training or law enforcement experience or anything like that, doesn't make his opinion invalid, but he's investigating. He did an episode on this case in La Crosse, Wisconsin, where there are these young men who get drunk and they walk across, by the riverfront at night. And there have been 10 or 11 young men who have drowned in the river, ostensibly intoxicated. And this Lore Lodge guy presented one such case in his episode, and he ordered the police reports. And he condemned the La Crosse Police Department in this episode for not being cooperative and not turning over the police reports, as if, their most important job is to provide YouTubers with the full docket of police reports that are available through open records requests, or that, the La Crosse Police Department is obligated in some way to answer, spend all their time answering questions from any YouTuber that comes along doing an investigation. And he says that, well, there very well could be a serial killer on the loose, and I've done this detailed investigation, right, of all these police reports, and I just thought he was a buffoon, right? Just to jump to the conclusion that, the police officer, how I feel about the police, right? But just to make all of us look stupid, people who are, actually interested in getting to the bottom of things, by like making these crazy accusations that, the police department is corrupt just because they don't want to spend time answering every YouTuber that calls all their questions, and insinuations that they did a bad job with their investigation. So anyways, you run the risk, having a public hearing like this, you run the risk of people making these crazy conclusions because they don't understand exactly what's going on. And I would caution everyone not to jump to conclusions based on what you see. When you are being live streamed a jury trial, there are certain things the jury's not supposed to hear, and you're not part of the jury, so you aren't put into a curated, carefully controlled trial like environment like that, where you're not supposed to see certain parts of evidence and you're not supposed to see certain arguments that are made. If this were a jury trial, which I understand it's not really, but if this were something like that, you wouldn't see this. You wouldn't see this part of it, because this is like, it's not a fact hearing per se, right? When you have a jury trial, the jury's being shown facts and they're asked to apply the facts to the law, or apply the law to the facts, right? We have if A, B, C, and D are met, then it's genocide. And if this were a jury trial, if A, B, C, and D were met, then it's genocide. We're going to show you a bunch of facts, and we need you to see if those facts fit into that genocide allegation, right? This is not even a fact-finding hearing at all. This is just the lawyers coming forward and saying, look, I'm going to offer this proof, right? Because we have this burden to meet. We have to show the court that this is I don't know what the burden of proof is, and we're going to get into that. But South Africa has to make a showing to the court saying, listen, these are the genocidal acts. This is how we think we can prove intent, basically what they're doing. And it's not an argument based on the credibility of the evidence. It's mostly based on the plausibility of the evidence. We're going to allege all these facts. We think we're going to make an offer of proof, and these are the acts we think are genocide. This is where we think the intent is. Please, based on those, we've made enough of a case for you to fear enough that there's a genocide taking place that you're going to put in acts to stop it, right? So with your untrained layman's brains, watch this. Try not to jump to conclusions about, how strong, try not to jump to conclusions, but think about how strong the case is and evaluate the evidence and claims, and try to do it dispassionately. Can be very difficult, especially with a topic like this. And actually, sorry, before we jump into that clip, just a little note, because I had mentioned the burden of proof, right? Well, we don't really know what that is in the as it applies to the ICJ. Here's a law review article I've referenced before. Well, it's not a law review article, but it's like it's not a law review article is like a long published thing. This is a blog post. But it's talking about how in the ICJ, in the civil law system, right, which is what most of like Europe operates on, as opposed to the common law system that we have in the United States and in Britain, the British legal system. In a common law system, it's adversarial, right? You have two parties facing off against each other. their interests are opposed and they fight. And we think the best way to get the truth is to have the parties fight against each other and compete. In that system, there are much more delineated burdens of proof. This side needs to show by beyond a reasonable doubt, the prosecution needs to show that the murderer committed the crime, that he, killed with premeditation, and he intended to do it, and it resulted in a death. And beyond a reasonable doubt means that they have to disprove every single theory that the defense has beyond a reasonable doubt, that there is no reasonable doubt as to whether or not the person committed the crime. In a civil law system, I'm not an expert on it, but it's more cooperative, and from my understanding, the burdens of proof are more up to the whims of the judge, that the judge acts more as a prosecutor in their role, and it's more of a collaborative type process. There's like an inquisition. So if we had Thijs, remember our friend Thijs van der Linde from the Netherlands that we had on the show a couple years ago, maybe I should reach out to him to explain how trials work in a civil law system. But so this article says demystifying standard of proof and its importance. So burden of proof is usually understood in conjunction with the concept of burden of proof, both of which are products of fact-focused adjudication in both domestic and international legal systems. Well, the burden of proof plays an allocative rule by placing the responsibility to prove a fact on someone. The former defines the extent of proof that has to be provided. Oh, okay. So in a civil law system, standard of proof is just like, okay, well, do we have enough proof? Burden of proof means that one side has to meet the showing of proof, which might be, I hope that's not confusing. So like in a civil law system, it's not adversarial. So they're just asking, well, is there enough proof here? Burden of proof in a common law system, an adversarial system, is like, you need to meet, one side is tasked with showing that there is the proof, instead of just, an inquisition as to, okay, where is the proof here? Is there enough proof? The burden of proving the existence of a fact is on the party that asserts the fact. This rule has also assumed the status of a well-established rule of procedure in international adjudication, which we don't know if that exists or not. That's up for debate, whether there's a well-established rule of how much proof there needs to be in international systems. And to me, this just blows my mind. And it's like, how can you operate a legal proceeding if there's a shifting burden of proof? If it's up to the whims of the judge and the court how much proof you need to have in order to succeed on your claims. That would drive me bonkers. So he talks about the difference between common law systems and civil law systems in international law, because remember, the member countries have a mixture of civil law and common law systems. While common law distinguishes between standards of proof based on the nature of the dispute as civil or criminal, right? In the common law, civil proceedings have a much higher burden of proof because you're directly involving liberty interests and putting people in jail based on what the ruling is. So that should be a high burden to meet. In a civil proceeding, it's more likely than not, because it's, you're not dealing per se with putting someone in prison and depriving them of, their liberty in that extreme degree. Civil law systems instead disregard any difference between civil and criminal cases, and instead rely on the personal conviction of the judge, which is insane to me. The lack of adherence to a single system in international law has resulted in varying standards of proof in cases before the ICJ. So it says, this is very interesting too. Over the years, adjudication before the ICJ has become fact-heavy, with the court increasingly focused on ascertaining the existence of disputed facts. Okay, that's what's going to happen after these provisional measure hearings and a ruling on the provisional measures takes place. They're going to get very fact-focused. There has been a marked transition from a hands-off approach in fact-finding to an active one in fact-heavy disputes. Legal provisions also signify the importance of the ICJ's fact-finding role. Article 49 of the Rules of the Court requires states to submit a memorial containing a statement of facts and the counter-memorial, like a memo, like a brief to the court, to contain an admission or denial of the facts. Oh, maybe that sounds like pleading a little bit. Article 36(2)(c) of the statute of the court makes reference to the facts which constitute a breach of an international obligation as a basis for the court's jurisdiction. So that's like a pleading, right? So if you have a problem and you want to sue someone, you get a summons, right, that tells someone there's being sued and tells them where and how to respond. Then you have an actual complaint, and they're talking about a complaint alleging specific facts that would entitle you to relief in front of the court. That's what they're talking about here. Meaning that the court, the ICJ in general, is becoming more fact specific, that they're dealing a lot with facts and allegations of facts that would entitle parties to relief. Because apparently in the past, they weren't as focused on like factual disputes, more so probably on legal disputes, which is an interesting development. At least it is to me. I hope it is to you, or you recognize that it's interesting, because that kind of means to me that the court is getting more and more involved in nitty-gritty specific triable disputes, instead of just like, okay, what is the law? You know, what is the law? We have this disagreement about what the law is and we need a court to say it. The difference is, you know, one is more sterile and the other is like much more involved. Like, this thing happened in the world and we need the court to figure out if it happened the way that they say it happened or the way that we say it happened, which just, I think, points to much more involvement in the international courts in more specific local matters, which has whole other implications. So the ICJ's position on the standard of proof, according to this article, the earliest case, which is also the first case that the ICJ decided in which it enunciated the standard of proof, was the Corfu Channel case. The dispute, initiated by the UK, related to Albania's alleged role in laying down mines or having allowed a third state to do so, the explosion of which had caused damage to British warships passing through the Corfu Channel. In its judgment holding Albania responsible, the court used as many as 3 expressions to describe the standard of proof: decisive legal proof, conclusive evidence, and a degree of certainty. That just seems wildly random to me and very vague and confusing as hell. While it might seem that the 3 different standards, decisive, conclusive, and certainty, were nothing more than adjectives used interchangeably, the creative use of multiple words was at cost of predictability in the court's approach. No shit. So in oil platforms, Iran alleged that the U.S.'s warships had destroyed oil production complexes in violation of the Treaty of Amity, 1955, and in international law. The U.S. premised its defense on the right of self-defense on account of the alleged Iranian attack on its own vessel, Sea Isle City. In refuting this contention, the court employed 2 standards of proof: sufficiency of the evidence and conclusive evidence, in holding that the U.S. had failed to discharge the burden of proof. The use of both terms was ambiguous, since evidence need not always meet both the standards. It may be sufficient without being conclusive, right? That's confusing as hell. How do they operate this way? But the court failed to clarify whether the evidence had to meet both the standards in order to be considered. This sounds like a kangaroo court to me. I don't know. That is incredibly disrespectful to say, but that, this is a long time ago, right? So Judge Bergenthal called out the court for changing the standard of proof from sufficient to conclusive without an explanation. What people do they have working on this court? And for the confusing use of the various terms to describe the standard. Other judges joined in pointing out the problems with the court's approach. Judge Awanda wanted the court to, quote, engage in much more in-depth examination of the issue of fact-finding and standard of proof. Judge Higgins was more trenchant in her critique. She felt that it was expected of the court to have, quote, clearly stated the standard of evidence. Yeah, no kidding. especially in a case that crucially depended on evidence. Judge Higgins also criticized the court's use of standards like sufficient and conclusive without adequately defining them. In the Bosnian genocide, and this is most important to what we're talking about today, the court dealt with the issue of in a more precise manner. The case brought by Bosnia and Herzegovina related to alleged violations of the Genocide Convention by the Federal Republic of Yugoslavia. Both the parties argued for two entirely disparate standards of proof, while the applicant, who was faced with the unenviable task of proving genocidal intent, demanded a, quote, balance of probability standard. The respondent wanted a stricter standard of beyond a reasonable doubt and proof of a proper degree of certainty. The court reiterated the standard laid down in Corfu Channel, quote, claims against the state involving charges of exceptional gravity must be proved by evidence that is fully conclusive, whatever that means. It, however, interchanged certainty with conclusive evidence in the earlier dictum. And again, dictum is part of a court opinion it's where the court ponders something and doesn't actually make a ruling about that thing that they say. So you could have the court saying, well, if it were this way, that would be the ruling. Well, that's not what the ruling is. It's just dictum. Lending credence to the fact that the standards in Corfu Channel were just an exercise in the creative use of vocabulary. It also introduced a new standard of fully convincing evidence, which was ostensibly inspired from the standard laid down in armed activities on the territory of the Congo. This standard applied both to allegations of commission of genocidal acts and to proof of attribution of the acts to the state. For allegations of failure to prevent the commission of genocidal acts and to punish the persons charged, the court demanded proof at a high level of certainty appropriate to the seriousness of the allegation. So, to me, that sounds like the general rule, right, of burden of proof in a genocide case. Maybe their general rule is the more serious the allegation, the larger the proof is, which kind of makes sense in a way. It's still kind of infuriating as an American criminal defense lawyer is like, okay, what do I need to prove? I want a certain standard of proof so I can try to meet that burden, or as a defense attorney to minimize the evidence so it doesn't meet that burden. But it seems like the standard of proof in these proceedings is that the more serious the offense is, the more serious the proof needs to be. And like genocide is the crime of crimes, mass killing for the purposes of exterminating a group of people. Like that is the highest crime that there is. So I would think that the standard of proof should be pretty high, and it should be in this proceeding. However, this is a preliminary injunction. So like in the United States, if you are asking for a preliminary injunction, you have to show that irreparable harm will happen if this thing is not stopped, and you have to show that you're likely to win on the merits of the underlying case. And it doesn't require you to show that you're going to win. You just have to show that you're likely to win. So that's what, with the shifting burden of proof that, it took a little time for us to get to the bottom of, which I apologize for, but like these things are complicated, and knowing the history of, the cases cited in this piece, I think is really helpful to see that in the beginning, the ICJ was like, anything goes. We're not even going to say what the burden of proof is. Maybe they didn't need to, right? Maybe it was not entirely a factual dispute, but some members of the court seem to think that it is important. Interestingly, the one with more English sounding names, that's probably not an accident. That's probably people like me being in a common law system really wanting like, okay, no, we need to know what the burden of proof is here in order to make a decision. But maybe they weren't fact intensive as much requiring that. I don't know, but you should have a burden of proof. So everyone knows what we're arguing and how and who wins and how that works, right? So I think, you go forward. It seems to me that they're going to say it'll be a relatively high burden of proof, maybe clear and convincing evidence. Like we just talked about, proof of a high level of certainty appropriate to the seriousness of the allegation. So anyways, I apologize for that aside, but I think it's really important to understand it and understand the history of it to really put all this in its proper context and understand exactly what's going on here. So we're going to watch this, her opening remarks, I think, and I'll do a pause and play to kind of say what I think about it and how to, if this were a jury trial, which it's not, but there is lots of public opinion hanging in the balance of this. And I think there were some accusations, at least, of emotional rhetoric, right? The BBC says, South Africa's genocide case against Israel. Both sides play heavy on emotion at ICJ hearing. Well, that's not necessarily a bad tactic. I think one side played a little heavier on emotion than the other. I think that's Israel, but that's just my opinion, man. Welcome to the portion of the show where I tell you how you can help support this content. The best way to do that, guys, is to go to libertyweekly.club. Yes, I haven't changed the URL yet, but this is my membership website that also functions as a newsletter. So if you go to that website, libertyweekly.club, hit the subscribe button in the upper right-hand corner, and you can subscribe for the free newsletter, and I send out a lot of free content. However, there is a section in those free emails that is premium, and that premium section includes early access to my episodes, access to bonus episodes, and preprints of my articles before they're published at the Libertarian Institute or other outlets. So again, go to the website, hit subscribe in the top right-hand corner, and sign up for that email list. You go through the page here and you can see all the content that I've set out in the past. There's a whole bunch of it, guys, and you get access to those previous emails that have gone out as well. Another way to help support me is to go to vitaldescent.com/Stitch Fix and sign up through my link there. You'll get $25 off your first order, and I will also get a $25 credit. Guys, I use this to buy my wardrobe. I'm a father of two. I have my own business. I do this, and I don't have time to go shopping. Can't haul the wife and kids around to have a leisurely shop for myself to pick these clothes. So what Stitch Fix does is that they pick the clothes for you. They send them to you in fixes, and it's really awesome stuff. These are all the pieces that I personally have bought myself. There's a lot of work stuff in there, but there's also casual stuff. I got an awesome plaid shirt that's in there, a flannel, really love that. I got this really cool sweatshirt. I got these awesome boots and a nice windbreaker, really good stuff. So go on over to vitaldescent.com/Stitch Fix. You can also get Vital Descent, really hard not to say Liberty Weekly, Vital Descent merchandise with the cool, awesome new logo from Mises Pieces. You can get all these kinds of things, all this merch. You got coffee cups, pint glasses, sweatshirts, premium t-shirts, premium sweatshirts, all that good stuff there at vitaldescent.com/merch. Also, guys, I started a TikTok channel, and I think that'll be really cool, trying to get more eyeballs on this content and more views. You can see it's already garnering a bunch of views, where I do anti-war cartoon reviews and a lot of cool stuff there. So vitaldescent.com/TikTok is where you can find me. My handle is at @PatMcFarlane_, the same as my Twitter handle. Okay, guys, that's about it. Check out those things. Please help support this content. Help me pay my producer and make the show better for you guys. Thanks. Again, this is not a trial. It's a legal proceeding for like a legal remedy that's not fact intensive per se. It's like arguing a motion. Like, did the pleadings meet the requirements for a pleading? So anyways, she's going to get forward. I really like this female attorney, by the way.
Thank you. Madam President, distinguished members of the court, it is a privilege to appear on behalf of the Republic of South Africa in this case of exceptional importance. It's a case that underscores the very essence of our shared humanity as expressed in the preamble to the Genocide Convention. It's my task to address the court on the genocidal acts that have led to this urgent request for provisional measures under Article 41 of the Statute of the Court.
So one thing that I learned early on as an attorney is a good attorney argues the law and a great attorney argues the judge, right? That being, know your audience. Essentially, that's what the lesson is. So if the judge is the one that is making the decision, then you want to tailor your arguments to that specific judge. What does that judge think about? What does that judge find convincing? What are the judge's values and morals? What is the demographics of the judge even matters. Now you have, in this instance, and it will show it again, you have a bunch of different judges from a bunch of different countries, right? You see them in the lower left-hand corner. In a jury trial, you want to tell a story. Whoever tells the best story wins the jury trial. And you can usually tell within the first minute of, it's not a clear rule, but you can usually tell in the first minute of opening statements in a jury trial who probably won the trial. It's that crucial. And whoever tells the best story is the one who wins. Now, in this instance, you're balancing whether or not, it's like, okay, do I want to be dramatic and tell a really emotionally gripping and attention-grabbing and persuasive story through narrative, through storytelling elements where there's characters, there's a struggle, there's a plot, and there's a theory that we're going to capture with this power of narrative. Using your hands and using the courtroom as your own theater to go about. In those respects, again, I still think it's important to be a little bit more theatrical, and we didn't really see that through these statements. I think that she did a fairly good job. It doesn't help to have notes, but I understand, I don't know. She could have done the 25 minutes without having a binder of notes that she keeps looking down at and reading from, albeit doing it well. But she has kind of a dry opening here. And I understand what the form is. You know, I understand you're in The Hague at an international court of justice, but I would have liked to see a little bit more theatrics in terms, not distasteful ones, but now she does tie it into like, we are here on the most solemn of occasions. This deals with our very humanity. This goes to the root of the entire question of why this court exists, why we've come together to form this tribunal, to prevent these cases from occurring, to prevent the crime of crimes, ladies and, your honors. And I would have liked to see a little bit more of that instead of kind of a bit of a dry and stuffy, we've come under the article number XYZ to come here to determine this and get, I would have liked to see a little bit more, although she didn't do a bad job.
South Africa contends that Israel has transgressed Article 2 of the Convention by committing actions that fall within the definition of genocide. The actions show a systematic pattern of conduct from which genocide can be inferred. Allow me to place these acts in context. Gaza is one of the two constituent territories.
So this is very, using a graphic, using some kind of a picture is very powerful in these proceedings, and visuals really help to tie in your narrative that you're trying to create, your story arc. And she uses a graphic right away, and I think that's a good choice.
Of the occupied Palestinian territories, occupied by Israel since 1967. It is a narrow strip of approximately 365 square kilometers, as depicted in the map now displayed. Israel continues to exercise control over the space, territorial waters, land crossings, water, electricity, electromagnetic sphere, and civilian infrastructure in Gaza, as well as over key governmental functions. As the Honourable Minister has said, entry and exit by air and sea to Gaza is prohibited, with Israel operating the only two crossing points. Gaza, which is one of the most densely populated places in the world, is home to approximately 2.3 million Palestinians, almost half of them children.
Now, I think it's really important to illustrate the fact that this is a population that is enclosed in a geographical area. Setting that narrative, which I believe is true and factual, but it is an important part of your narrative of your case, your theory of your case going forward.
For the past 96 days, Israel has subjected Gaza to what has been described as one of the heaviest conventional bombing campaigns in the history of modern warfare. Palestinians in Gaza are being killed by Israeli weaponry and bombs from air, land, and sea. They are also at immediate risk of death by starvation, dehydration, and disease as a result of the ongoing siege by Israel, the destruction of Palestinian towns, the insufficient aid being allowed through to the Palestinian population, and the impossibility of distributing this limited aid while bombs fall. This conduct renders essentials to life unobtainable. At this provisional measures stage, as this court has made clear in the Gambia-Myanmar case, it is not necessary for the court to come to a final view on the question of whether Israel's conduct constitutes genocide. It is necessary to establish only whether at least some of the acts alleged are capable of falling within the provisions of the convention.
Bam, that's really important. So we talked about the Gambia-Myanmar case already because it's the last, I think it's the last ruling that was that came before the court, that the court made the decision, yes, we are going to institute provisionary measures. So she's talking about, in a way, the burden of proof, or what the court needs to find. And she is establishing that as being really important because they're, describing what it is that you need to prove. Says, now, court, I only need to prove this much. That's all you need to find in my favor is just to go right there. Very important.
On analyzing the specific and ongoing genocidal acts complained of, it is clear that at least some, if not all of these acts, fall within the Convention's provisions. These acts are documented in detail in South Africa's application and confirmed by reliable, often UN sources. It's thus unnecessary and impossible for me to recount all of them.
So again, she's setting the scope of what she needs to prove. An important part of that is like, listen, UN officials, your own officials, think I'm right. And of course, like I said, this is not a fact-finding hearing here. She's making offers of proof. An offer of proof is like, if I had the opportunity, Your Honor, I could put a witness on the stand and we could evidence up this claim. I'm going to offer it because that's all I can do right now. But this is a showing of proof to say what I'm asserting.
I will highlight only some in order to illustrate the pattern of genocidal conduct. The UN statistics that are relied upon are up to date as of 9 January 2024. In South Africa's oral submissions, we will illustrate the facts that we rely on with limited use of audiovisual material. Madam President, we do so with restraint and only where necessary, and always with respect to the Palestinian people.
That's important too, because she could show like some horrible like dismemberment, like terrible gore and things, and that would actually kind of reflect poorly on South Africa's decision if they were to use something that were overtly sensational to the point of being prejudicial to Israel, putting up something that's just awful and it doesn't have a whole lot of evidentiary value. Like its probative value is outweighed by the risk of undue prejudice. It's salacious in that sense. And she's telling the court, now listen, we have horrible, horrible shit, but we're not going to just dump that to try and get an unfair advantage because we know it tears at the heartstrings. But we're doing it because we need to, and we're using discretion and restraint.
Against this background, I move now to demonstrate, in turn, how Israel's conduct violates Articles 2A, 2B, 2C, and 2D of the Convention. The first genocidal act committed by Israel is the mass killing of Palestinians in Gaza, in violation of Article 2A of the Genocide Convention. As the UN Secretary General explained 5 weeks ago, the level of Israel's killing is so extensive that nowhere is safe in Gaza. As I stand before you today, 23,210 Palestinians have been killed by Israeli forces during the sustained attacks over the last 3 months, at least 70% of whom are believed to be women and children. Some 7,000 Palestinians are still missing, presumed dead under the rubble. Palestinians in Gaza are subjected to relentless bombing wherever they go. They are killed in their homes, in places where they seek shelter,
with some pictures of
in
mass
hospitals,
graves,
in schools, in mosques, in churches, and as they try to find food and water for their families.
So she goes through, several points that she says are genocidal acts committed by Israel. And I'm not going to play through all of it just in the interest of time. We are going to hear from her colleague who talks about genocidal intent, which I think is the harder case. I think the genocidal acts is the easier element to prove of the act portion, but that intent is important as well. So this gentleman here is coming forward to talk about intent.
Distinguished members of the court, it is a privilege to appear before the court on behalf of South Africa. I will address Israel's genocidal intent. At this stage, the court is not required to determine that the only inference to be drawn from the available evidence is genocidal to order provisional measures, as that is to decide the merits. Rather, the assessment of the existence of an intent to destroy could be made by the court only at the stage of the examination of the merits. That some of the alleged acts may also amount to atrocities other than genocide does not exclude the finding of plausible acts of genocide. Madam President, South Africa is not alone in drawing attention to Israel's genocidal rhetoric.
I would have liked to have heard a little bit more from this gentleman about what the court should, like the first woman who was just talking. She says, "Well, court, you don't have to find. All you have to find for me to win is this." And he says, basically, he tells the court, "Well, you don't have to you don't have to find genocidal acts, in fact, it says you shouldn't find genocidal acts because you can't until that would be judging the merits of the case. So don't think that you should find genocidal acts, but he doesn't say, this is all you have to find for me to win. He just says, you shouldn't find genocidal acts because that would be ruling on the merits of the case. I don't see how that's helpful for him.
Against Palestinians in Gaza. 15 United Nations special rapporteurs and 21 members of the United Nations working groups have warned that what is happening in Gaza reflects a genocide in the making and an overt intent to destroy the Palestinian people under occupation. Israel has a genocidal intent against the Palestinians in Gaza. That is evident from the way in which Israel's military attack is being conducted, which has been described by Ms. Hassim SC. It is systematic in its character and form. The mass displacement of the population of Gaza, headed into areas where they continue to be killed, and the deliberate creation of conditions that, quote, lead to a slow death, unquote. There is also the clear pattern of conduct, the targeting of family homes and civilian infrastructure, laying waste to vast areas of Gaza, and the bombing, shelling, and sniping of men, women, and children where they stand, the destruction of the health infrastructure, and lack of access to humanitarian assistance. So much so that as we stand today, 1% of the Palestinian population in Gaza has been systematically decimated, and 1 in 4 Gazans have been injured since 7 October. These two elements alone are capable of evidencing Israel's genocidal intent in relation to the whole or part of the Palestinian population in Gaza. However, third, there is an extraordinary feature in this case, that Israel's political leaders, military commanders, and persons holding official positions have systematically and in explicit terms declared their genocidal intent. And these statements are then repeated by soldiers on the ground in Gaza as they engage in the destruction of Palestinians and the physical infrastructure of Gaza.
Okay, I think that's enough to kind of see those two prongs. So the first case, of course, is, and I think this is the strongest, and I understand why he leads with this, and I think it's compelling, is the argument is, well, genocidal intent, you can see it clearly from the actual actions that the IDF and Israel takes, right? You go in, they go in rather, and they do A, B, and C. What else are we to read from that other than genocidal intent, right? What would be the reason that they would be destroying, bombing families, killing mass, civilians? Most of the people they kill are civilians. The vast majority of people that they kill are civilians. They're killing critical infrastructure. They're denying humanitarian aid. They're doing all these things. What other explanation could there be for that than intent to destroy in whole or in part, right? His second point is, well, listen to what their leaders are saying. Their leaders are openly declaring a genocidal intent, their genocidal intent. And of course, there is a defense to that, and that's why I'm sure he led, that was the second, not the first point, the second point, because the rebuttal to that is, okay, well, those people aren't speaking, they're not saying, when they say they have genocidal intent, they're not speaking as official doctrine. It's not official policy. These are some rogue officials who are first of all, they'd probably say, well, that's not a genocidal intent, what they're saying. The actual things they're saying is not constitute genocidal intent. But they would also say that's not official policy of genocidal intent. It's not an official policy of genocide. That is just things that random people are saying. So let's, I'm going to go now and kind of off screen try to find the second one. Now it's really hard to, there is no actual highlights clip. Like no one has taken the 3 hours and chopped them down into manageable clips. So here is the Israeli attorney. So we're just going to hear in his own words just a little bit what the rebuttal is, and then dive into some analysis from other parties, other people.
Madam President, distinguished members of the court, it is an honor to appear before you again on behalf of the State of Israel. The State of Israel is singularly aware of why the Genocide Convention, which has been invoked in these proceedings, was adopted. Seared in our collective memory is the systematic murder of 6 million Jews as part of a premeditated and heinous program for their total annihilation.
So his opening remarks is to play the Jew card. Seriously. I don't know. It's like I'm trying to evaluate it from like a neutral, detached third point of view, but and it might be a good strategy. It might be a good emotional strategy too. I don't know. I wouldn't start with the Jew card saying that, listen, guys, there's no way that Israel could be committing genocide right now because our genocide was the reason why this entire court exists in the first place. So because we were genocided 60 years ago means that we are likely not guilty of genocide right now. But of course, I mean, you see a little bit later that plays into the perpetual victimhood defense that the Jews have. Their defense is, sorry, I shouldn't say the Jews. I should say Israel because it's not, of course, not all Jews are. Well, Israel would say that all Jews everywhere are citizens of Israel, perhaps in a sense, but by birthright, right? No, but it's the perpetual victimhood that the Israelis have on behalf of all Jews. It's anti-Semitic, it's disgusting, and it is their defense. It's like the first words that he speaks when he gets up there is, well, the Jews were genocided, we're the OG genocide victims. But it does tie into their theory of the case, and I guess I understand why he would do it is, well, look at us. We're the perpetual victims. We were victims then, and we're victims now. Everyone just has it out for the Jews. And we need to do what we need to do. You got to break a few eggs to make an omelet, right? We need to act in self-defense. And sometimes acting in self-defense. I'm going to play devil's advocate here. But I mean, everyone should know that I'm not on Israel's side. So I'm trying to be neutral in a certain way. But if we play devil's advocate, I guess it is a theory of the case. I don't know if it's the one that I would choose, but it's the theory of the case is we are the victims of genocide. We continue to be the victims of genocide. People are out to get us. We need to do what we need to do to protect ourselves.
Given the Jewish people's history and its foundational texts, it is not surprising that Israel was among the first states to ratify the Genocide Convention without reservation and to incorporate its provisions in its domestic legislation. For some, the promise of never again for all peoples is a slogan. For Israel, it is the highest moral obligation. Raphael Lemkin, a Polish Jew.
That's even more damning of their actions. How else do you explain your actions?
Who witnessed the unspeakable horrors of the Holocaust is credited with coining the term genocide. He helped the world recognize that the existing legal lexicon was simply inadequate to capture the devastating evil that the Nazi Holocaust unleashed. The applicant has now sought to invoke this term in the context of Israel's conduct in a war it did not start and did not want. A war in which Israel is defending itself against Hamas, Palestinian Islamic Jihad, and other terrorist organizations whose brutality knows no bounds.
So if you're thinking about it from a devil's advocate point of view, right? Framing is everything. What story to tell and where to start that story is very important too. And clearly the story starts with Israel being like the perpetual victim, and then the clock starts again on October 7th. So none of the context from before October 7th matters, right? The only context is that Israel didn't want this war. Israel didn't start this war. We're just defending ourselves because we were attacked on October 7th, which is when history begins again after, it started when we started this whole genocide thing, and now you're accusing us, and then now we restart the clock on October 7th.
The civilian suffering in this war, like in all wars, is tragic. It is heartbreaking. The harsh realities of the current hostilities are made especially agonizing for civilians, given Hamas's reprehensible strategy of seeking to maximize civilian harm to both Israelis and Palestinians, even as Israel seeks to minimize it. But as this court has already made clear, the Genocide Convention was not designed to address the brutal impact of intensive hostilities on the civilian population, even when the use of force raises, quote, very serious issues of international law and involves enormous suffering and continuing loss of life, end quote. The convention was set apart to address a malevolent crime of the most exceptional severity. We live at a time when words are cheap. In an age of social media and identity politics, the temptation to reach for the most outrageous term, to vilify and demonize, has become for many irresistible.
So he's saying that it's a meme, like an internet meme, that Israel is committing, that they're weaponizing the term genocide to throw at Israel because it's the worst thing, like as an offensive weapon, using the court as a sword instead of a shield. Which, I don't know, I guess it makes sense if you're in Israel's position. Like, how do you defend what's happening on the ground, like the facts as presented about deaths and who's involved, and Israel's specific attempts to limit humanitarian aid and prevent that from reaching people? How would you go at it? Like, think about if you were that man and you were tasked with defending those actions, and the statistics of who's all been killed and how.
But if there is a place where words should still matter, where truth should still matter, it is surely a court of law. The applicant has regrettably put before the court a profoundly distorted factual and legal picture. The entirety of its case hinges on a deliberately curated, decontextualized, and manipulative description of the reality of current hostilities. South Africa purports to come to this court in the lofty position of a guardian of the interest of humanity. But in delegitimizing Israel's 75-year existence in its opening presentation yesterday, that broad commitment to humanity rang hollow. and in its sweeping counterfactual description of the Israeli-Palestinian conflict, it seemed to erase both Jewish history and any Palestinian agency or responsibility.
Perpetual victimhood.
Indeed, the delegitimization of Israel since its very establishment in 1948 in the applicant submissions sounded barely distinguishable from Hamas's own rejectionist rhetoric.
Oh, so South Africa is
unsurprising,
Hamas.
therefore, that in the applicant's telling, both Hamas's responsibility for the situation in Gaza and the very humanity of its Israeli victims are removed from view. The attempt to weaponize the term genocide against Israel in the present context does more than tell the court a grossly distorted story. And it does more than empty the word of its unique force and special meaning. It subverts the object and purpose of the convention itself, with ramifications for all states seeking to defend themselves against those who demonstrate total disdain for life and for the law. Madam President, members of the court, on Saturday, October 7th, a Jewish religious holiday, thousands of Hamas and other militants breached Israeli sovereign territory by sea, land, and air, invading over 20 Israeli communities, bases, and the site of a music festival. What proceeded, under the cover of thousands of rockets fired indiscriminately into Israel, was the wholesale massacre, mutilation, rape, and abduction of as many citizens as the terrorists could find before Israel's forces repelled them. Openly displaying elation, they tortured children in front of parents and parents in front of children, burned people, including infants, alive, and systematically raped and mutilated scores of women, men, and children.
So these facts are all contested, right? But even what they're saying, so I don't think that he's doing a good job. I mean, at least it's not the way that I would defend Israel, and I'll explain how I would defend Israel. But this is not a jury trial, right? I don't know if the judges care about all of this like perpetual victimhood stuff and like the more emotional tying this to, you know, but what about Hamas? This is what happened to Israelis on October 7th, right? Who gives a shit? I mean, it's not relevant to the case. The case is about Israel committing genocide against civilians or killing en masse women and children. How is what Hamas did to Israeli civilians relevant to the question of, is Israel killing women and children, Palestinians, with intent to commit genocide? Now, maybe there's some relevance in terms of, well, we're justified in attacking Hamas because we were attacked. Therefore, we're going out to kill Hamas, and war is hell, and killing Hamas is very important. And killing those civilians is an inevitable, unavoidable consequence of going after Hamas, which is what we are entitled to do. If that were true, you would also have to demonstrate that we are taking the utmost precaution of protecting Palestinian civilians. And you would have to at least demonstrate how many Hamas members that you have killed and dispatched as a ratio from Hamas to Palestinian. And maybe he's going to get into that in his framing.
All told, some 1,200 people were butchered that day, more than 5,500 maimed, and some 240 hostages abducted, including infants, entire families, persons with disabilities, and Holocaust survivors.
I mean, again, not relevant because the Palestinians didn't do that.
Many of whom have been tortured, sexually abused, and starved in captivity. Representatives of the hostages' families are in this courtroom today, and we acknowledge their presence and their boundless suffering. We know of the brutality of October 7th, not only from the harrowing testimonies of the survivors, the unmistakable proof of carnage and sadism left behind, and the forensic evidence taken at the scene. We know it because the assailants proudly filmed and broadcast their barbarism.
Show us the footage.
The events of that day are all
Again,
but
these are
ignored in
offerings
the
of
applicant's
proof.
submissions. But we are compelled to share with the court some fraction of its horror.
Okay.
The largest calculated mass murder of Jews in a single day since the Holocaust. We do so not because these acts, however sadistic and systematic, release Israel of its obligations to uphold the law as it defends its citizens and territory. That is unquestionable. We do so because it is impossible to understand the armed conflict in Gaza without appreciating the nature of the threat that Israel is facing and the brutality and lawlessness of the armed force confronting it. In the volume of materials submitted to members of the court, access has been provided to a portion of the raw footage for separate screening. But I am obliged to put before the court today some small fragment of the scenes of unfathomable cruelty that took place in hundreds of locations on that horrible day. Johnny Simantov, a wheat farmer, and his wife Tamar, an activist for women's rights, lived in kibbutz Nir Oz.
I just want to
territory.
replay that portion because he said something that's important.
That is unquestionable. We do so of that day are all but ignored in the applicant's submissions. But we are compelled to share with the court some fraction of its horror. The largest calculated mass murder of Jews in a single day since the Holocaust. We do so not because these acts, however sadistic and systematic, release Israel of its obligations to uphold the law as it defends its citizens and territory. That is unquestionable. We do so because it is impossible to understand the armed conflict in Gaza without appreciating the nature of the threat that Israel is facing and the brutality and lawlessness of the armed force confronting it.
Okay, so that's pretty important, and I think that's where I'm going to end the Israeli portion. I would encourage everyone to go through and watch all of it because there is a showing, there are some showings at least of Hamas atrocities on that day. But before that, if you caught that, he was giving some snide remarks to the South African side, and snide looks over there, saying that the South African side completely ignored the atrocities of Hamas against Israelis occurring on October 7th. Well, they did because it's not relevant. It's not relevant. And he says that, we're not presenting what Hamas did. Even the Israeli attorney said, we're not presenting what Hamas did as an argument to say that Israel doesn't have to abide by the law in its response. We're doing it because it provides broader context to explain why Israel is acting the way that it does, okay? And I think that is a misdirection. And maybe it's an intelligent one. I don't know. We'll see if it's effective in the end. But he says, because then the question becomes, well, is Israel operating within the bounds of the law in its response? The question is not, okay, well, if he admits that Israel needs to act within the bounds of the law in its response, then let's hear about that, and let's not hear anything about, sure, we will stipulate, maybe South Africa should have done this. We will stipulate, Your Honor, that Israel was attacked and that the actions of Hamas were unjust. We will stipulate that. Let's not even have a misdirectional get buried in the weeds arguing about what happened to Israel in terms of the atrocities committed by Hamas on that day. Let's take that for granted. How does that, it does not, but how does it affect what happened after that in Israel's response? And did Israel's response comport to the law? Now, it seems like that's this gentleman's portion of responsibility, that this first attorney was to get forward. This one here was to come out and talk about how terrible Hamas was, like we haven't heard that. Then this individual, it seems like his responsibility is to come out and to explain how Israel is complying with the law in its response.
These terrorists, supported by their friends in Tehran, will never stop. And so Israel has the right to defend itself in line with humanitarian law.
Yeah, in line with humanitarian law, right? He should summarize what he was going to say in the first little bit here.
Madam President and members of the court, it is a great honor to appear before you again and a privilege to appear on behalf of the State of Israel. It is my task today to address the issues falling within the general categories of prima facie jurisdiction and the...
Oh, so he presents the legal argument as to why the case shouldn't go forward, the jurisdictional one. Let's see what this lady...
The Genocide Convention is actually relevant. Members of the court, it is an honor to appear before you on behalf of the State of Israel. As Professor Shah noted, at this stage, South Africa does not need to prove that genocidal acts have been or are being committed. But it does have to show that the Genocide Convention is actually relevant. It has to show some level of acts and some level of intent. Professor Shah has spoken to the issue of express intent. It is my task to speak to the circumstances of Israel's actions. Israel cannot possibly comprehensively address today all of the allegations made in South Africa's application in this regard. The applicant paints a dire picture, but it is a partial and deeply flawed picture. The application is so distorted in its descriptions that it prevents the court from properly assessing the plausibility of the rights asserted by South Africa. Plausibility cannot be determined based on the unsubstantiated allegations of one party to the proceedings alone, if Article 41 of the court statute is to have any meaning. In the time available, I will address three aspects of reality on the ground that the applicant has either ignored or misrepresented. First, Hamas's military tactics and strategy. Second, Israel's efforts to mitigate civilian harm during operational activity. And third, Israel's efforts to address humanitarian hardship in Gaza, despite Hamas's attempts at obstruction. With respect to Hamas's military tactics and strategy, it is astounding that in yesterday's hearing, Hamas was mentioned only in passing and only in reference to the October 7 massacre in Israel.
She is the most effective of the three attorneys that have spoken so far. This should have been the first, I think this should have been the first point in their response.
Listening to the presentation by the applicant, it was as if Israel is operating in Gaza against no armed adversary, but the same Hamas that carried out the October 7 attacks in Israel is the governing authority in Gaza. And the same Hamas has built a military strategy founded on embedding its assets and operatives in and amongst the civilian population. Urban warfare will always result in tragic deaths, harm, and damage. But in Gaza, These undesired outcomes are exacerbated because they are the desired outcomes of Hamas. In urban warfare, civilian casualties may be the unintended but lawful result of attacks on lawfully military objectives. International humanitarian law recognizes this reality and provides a framework for balancing military necessity with humanitarian considerations. These do not constitute genocidal acts. In the current conflict, many civilian deaths are directly caused by Hamas. Booby-trapped homes detonate and kill indiscriminately. Mines in alleyways collapse structures around them. And over 2,000 rockets, misfired by Hamas, have landed inside Gaza, causing untold levels of harm. One telling example is a blast at the Al-Hali hospital on October 17. Hamas claimed that the Israel Defense Forces, the IDF, attacked the hospital. Headlines around the world rushed to repeat this claim. The IDF later proved, and US intelligence and other national security intelligence agencies independently confirmed that the blast was the result of a failed launch from within Gaza.
Okay, well, so this is really effective in terms of like putting your best case for. I think it ultimately fails in my opinion, but this is, I think, the most effective of the three in terms of really getting to the actual meat of what your defense is or should be, right? This is the strongest case that Israel has as to why they're not committing genocide, in my opinion. Maybe it was good to get, that first guy in and to kind of set the theory of the case, establish that, poor Israel, we're the ultimate victims, we're the perpetual victims. Hamas came in and they're the big enemy and they're this existential threat. Not mention that, Israel propped up Hamas and has a long-standing history of propping up Hamas, as, told by Benjamin Netanyahu, in order to avoid a two-state solution, but not mention how, the Hannibal Doctrine, or how there's a lot of evidence out there that, of course, you wouldn't mention it, right? Because you're a defense attorney defending Israel, so you wouldn't mention all of these inconvenient facts that I think the prosecution should bring out. Maybe they should have anticipated this argument, and maybe they did. Maybe I just didn't see it or present it. But, the Hannibal Doctrine, that there was foreknowledge that Hamas would attack, that, the funding, Netanyahu has funded Hamas over and over again repeatedly as a thwart to a two-state solution. But again, the Hannibal Doctrine, that the Israeli military is actually responsible for a lot of deaths that occurred on October 7th by directly firing on their own civilians. Of course, you can't litigate the issue of the atrocities on October 7th, how many of them were actually committed by Hamas, because some of them were, probably a number of it was, but a lot of it also was unsubstantiated allegations. But this, I think that she should have gone first. She should have, pulling at the heartstrings with the Hamas stuff. I guess it makes me roll my eyes, but it might not make others roll their eyes. But yeah, the presentation that she's making is much more effective. Like, listen, this is the legal argument. We are fighting a war, and Hamas in, VC, Viet Cong style has embedded themselves with the civilian populace, and there is literally nothing that we can do because we have a right to defend ourselves, and we need to roll through the streets and fight an urban warfare guerrilla war as an established power fighting an insurgent force. I think that's your best argument. I think it ultimately probably fails because you're in there in the trenches using 2,000-pound bombs that strike civilian targets, and you're using a sledgehammer when a scalpel is required, and you're doing all these things, preventing aid from coming in. maybe under the maybe your defense to that is, well, listen, we want aid to come in, but Hamas keeps seizing the aid trucks. Maybe that's what the defense is. I don't know, because I don't have 8 hours to sit and watch and analyze all of this, but maybe that's what your defense is. But I think it ultimately fails because of those key points, right? That that aid is being pushed back. They're not allowing the Palestinians to leave, or they're trying to deport them, which is an act of genocide in of itself. I think what you would do, or what you should do, is try to take these Palestinians in, or at least provide tons of direct aid from Israel itself to the Palestinians, or take them into Israel itself and set up aid camps, and do those things while we move in a military operation to eliminate Hamas. Say, everyone who comes through has safe passage and have these checkpoints. And then if these humanitarian checkpoints are being attacked by Hamas, suicide bombers or something like that, it's pretty clear, like, look, we're trying to bring these Palestinians through, but Hamas is blowing up these humanitarian checkpoints. I don't know, but that's just my opinion. So
It was not, as Hamas claimed, the fault of the IDF.
So, oh yeah, and then she cites all these. Oh, well, the U.S. military, the entity that gives us all our weapons and money, and their intelligence agencies did an independent review of this hospital bombing and said it was Hamas that did it, right? But all this comes out later, or it will come out later in litigation and briefing and actual factual contentions. So that's all we have time to go through the actual video of it. I just want to go through the last bit here, the Jeremy Scahill piece. And Jeremy is very pro-Palestinian. So again, take it for what it is. But he says, a team of Israeli lawyers and officials presented their defense at The Hague on Friday in the second day of the genocide case brought before the International Court of Justice by the government of South Africa. The lawyers portrayed Israel as the actual victim of genocide, not Gaza, accused South Africa of supporting Hamas, and painted South Africa's government as functioning as the legal arm of the Palestinian militants who led the deadly raids into Israel on October 7th. One interesting thing is, if Israel is arguing that they are acting to prevent a genocide of Israelis, I think they have to address at some point the power differential between Israel and Hamas. That Israel is, as a state, has one of the most heavily armed militaries in the world, and Hamas is a group of guerrilla fighters that has no possible prospects of ever conquering Israel and systematically exterminating the populace. In any real sense of reality, that's not a possibility. Or maybe they should argue that it is a possibility, that Palestinians, if left unchecked, if let out of their prison, are going to push all the way from the river to the sea and exterminate all Israelis with clubs, because that's all they have. I mean, or as opposed to Hamas with their bottle rockets and, their AKs and their homemade RPGs and stuff like that. I mean, that is enough to fight a guerrilla war against an occupying force, but it's not enough to conquer a people and systematically exterminate them. That's something I think they would have to legitimize if they didn't, and I just haven't seen it because, we're getting a small cross-section in this 2-hour episode. Israel benefited greatly from the fact that there was no cross-examination permitted or debate allowed during these proceedings. It would be nice if there was a back and forth allowed. It embarked on a bold mission to do in a court of international law what its military and political officials have done day and night throughout the course of this war against Gaza: unleash a deluge of what was known within the Trump administration as alternative facts. Israel's defense, and sorry, I'm freezing my ass off. My basement is cold. Israel's defense was the inverse of South Africa's case yesterday, and as weak in offering documented facts as South Africa's was powerful. History began on October 7th. The Israelis seemed to say, South Africa is Hamas. South Africa did not give Israel a chance to meet up and chat about Gaza before suing for genocide. And actually, the Israel Defense Forces is the most moral entity on earth. As for the voluminous public statements by senior Israeli officials indicating genocidal intent, those were just, quote, random assertions by some irrelevant underlings. Prime Minister Benjamin Netanyahu's statements invoking a murderous story from the Bible about killing the women, infants, and cattle of your enemies, the South Africans just don't understand theology and presented Netanyahu's words out of context. So Jeremy Scahill, he's not exaggerating in some of this. South Africa is Hamas, for instance. South Africa did not give Israel a chance to meet up and chat about Gaza before suing for a genocide. That was Israel's jurisdictional objection, which has merit. I mean, I wouldn't infer anything about the weakness of Israel's case that one of their primary arguments against the preliminary findings is a jurisdictional argument. Some people have been looking at it and have been saying, look, their defense is so bad that they're relying on, like, they're not, part of their defense is not a denial of the facts as they exist or the intent. It's a jurisdictional argument. And I wouldn't discount Israel anything just based on the fact they're making a jurisdictional argument. While Israel's lawyers made legal arguments that the genocide charges leveled against it are invalid, their primary strategy was to appeal to the court on jurisdictional and procedural matters. I don't know if as an attorney, I don't think I really infer anything by that, much of anything at all. I don't think it matters. You lead with what you think is your strongest case. And Israel intelligently tried to set an alternative narrative at the beginning of their case. I think it's an irrelevant alternative narrative, but maybe it's the most effective one. I'm not sure. We'll see what happens, but I think it's irrelevant. But it's also irrelevant. You can't infer anything that one of their primary defenses is jurisdictional. That's just smart lawyering. Maybe the optics of it aren't as bad, but it is what it is. Scahill continues, hoping that they could form the basis for the panel of international judges to dismiss South Africa's case. Aware of the global audience, Israel also sought to reinforce its claims of righteousness and self-defense in fighting the war in Gaza. Israel's representative Tal Becker opened his government's rebuttal by telling the judges of the ICJ that South Africa's case, quote, profoundly distorted the factual and legal picture, claiming it sought to erase Jewish history. Sorry. He charged that the legal arguments made by South Africa's team were, quote, barely distinguishable from Hamas's rhetoric and accused them of weaponizing the term genocide. Yeah, that was annoying. That was a bitch move, really, in my profound legal opinion, professional opinion. Becker called October 7th, quote, the largest calculated mass murder of Jews since the October 7th, since the Holocaust, and pleaded with the court to factor in the, quote, brutality and lawlessness of the enemy Israel says it is fighting in Gaza. Israel, he said, has a lawful right to use all available means to respond, quote, to the slaughter of October 7th, which Hamas has vowed to repeat. I think what he really said is that Israel has a lawful right to use all available legal means to respond to the slaughter of October 7th, which Hamas has vowed to repeat. I mean, you heard it yourself. At the beginning, he did say, you know, it's important for Israel to respond within the law. He did say that. He repeatedly attacked the South African government, accusing it of doing Hamas's bidding and alleging that its true agenda was to, quote, thwart Israel's right to defend itself. Quote, South Africa enjoys close relations with Hamas, Becker said. These relations have continued unabated even after the October 7th atrocities. He said that South Africa, not Israel, should be subjected to provisional measures by the ICJ for its alleged support of Hamas. Becker neglected to mention the fact that Netanyahu himself long advocated for Hamas to retain power in Gaza and work to ensure the flow of money to the group from Qatar continued over the years, believing it to be the best strategy to prevent the establishment of a Palestinian state. Becker rejected South Africa's characterization of the historical scale of civilian destruction in Gaza, which has now killed over 10,000 children, arguing that what is actually, quote, unparalleled and unprecedented in this war is Hamas, quote, embedding its military operations throughout Gaza within and beneath densely populated areas. Becker spoke as though many of Israel's most outlandish claims about Hamas's underground operations have not been proven false or shown to be greatly exaggerated, such as the Israeli claim that there was essentially a Hamas Pentagon under Al-Shifra Hospital. Sorry, I'm having some pretty lung reactions here you can hear. Sorry. Becker has also alleged that South Africa's lawyers had failed to mention how many of the buildings blown up and destroyed in Gaza over the past 3 months of sustained Israeli bombing were actually, quote, booby-trapped by Hamas rather than destroyed by Israel. It was a risible claim, given not only the scale of the Israeli bombardment of entire neighborhoods, but also because Israeli soldiers have posted videos of themselves gleefully hitting the detonate button to obliterate whole neighborhoods. He dismissed civilian death and injury figures provided by Gaza health authorities, saying that South Africa's lawyers had failed to mention how many of the dead Palestinians were actually Hamas operatives. It was a striking point given that Israeli officials have openly and repeatedly said that there are no innocents in Gaza and that United Nations workers and journalists killed by Israel are actually secret Hamas agents. So, I mean, the majority of civilian dead are women and children. I would assume that it's assumed that the women and children are not Hamas fighters. The nightmarish environment created by Hamas has been concealed by South Africa, Becker charged. Israel is committed to comply with the law, but it does so in the face of Hamas's utter contempt for the law. Okay, so Jeremy Scahill does quote that part. Becker did not bother to address any of the scores of UN resolutions over the decades condemning the illegality of Israel's apartheid regime and its illegal occupations, not to mention its own well-documented use of Palestinian children as civilian shields and the intentional killing and maiming of nonviolent protesters. There's links here if you want to read this by Jeremy Scahill at the Intercept. Becker also claimed that Israel was complying with international law in all of its operations in Gaza. Quote, Israel does not seek to destroy a people, but to protect a people, its own people. Okay, what about the Palestinians? I don't know. Is there a self-defense claim? I guess that would be like in U.S. law, if you were charged with murder, you could have a self-defense affirmative defense, saying that, yes, I killed the person, but it was self-defense. Is there any genocide self-defense, like a self-defense genocide? Maybe that would just be a attack on the claim of intent to kill in whole or in part. It's narrative warfare. I mean, it's telling a different story, which is smart to do if you're tasked with defending Israel. There could, quote, hardly be a charge more false and more malevolent than the charge of genocide. He accused South Africa of abusing the World Court and turning it into, quote, an aggressor's charter. Malcolm Shaw, a British lawyer representing Israel, opened his argument by attacking South Africa's reference on Thursday to what it described as Israel's 75-year Nakba against the Palestinians. Shaw called this characterization as, quote, outrageous, and said the only relevant historical context were the events of October 7th, which he termed the real genocide in the situation. So, less than 1,500 people. Given the civilian death toll caused by Israel in Gaza, upward of 23,000 as of this week, it was a stunning statement. By Israel's own official count, some 1,200 people were killed on October 7th. Of these, 274 were soldiers, 764 were civilians, 57 were Israeli police, and 38 were local security guards. It has still not been determined how many Israelis were killed in, quote, friendly fire incidents by Israeli forces who responded to the Hamas attacks that day. Shaw and other lawyers representing Israel acknowledged that civilians had been killed during Israel's military operations, though Shaw contended that, quote, armed conflict, even when fully justified and conducted lawfully, is brutal and costs lives. But he said Israel was engaged in a lawful and proportionate military campaign, and said the ICJ was not an appropriate venue to review the Gaza war. Quote, the only category before this court is genocide. Not every conflict is genocidal, Shaw asserted. If claims of genocide were to become the common currency of our conflict, the essence of this crime would be diluted and lost. Now, that is interesting. I don't necessarily disagree with that as a strategy. I think the facts play out. I think the facts sustain South Africa's case. I think it is the proper venue and the proper place to be like litigating this conflict. But I think it's a good strategy for this attorney, Shaw, to be asserting, right? It's a good argument. Again, I don't think it carries the day, but it is a good argument. Shaw spent much of his time arguing that South Africa had failed to follow the mandated procedures for bringing a third-party genocide charge before the World Court. He accused South Africa's government of failing to sufficiently engage in direct communications with Israel to inform it that there was a conflict between the two states. South Africa, quote, seems to believe that it does not take two to tango, he said. South Africa, quote, decided unilaterally that a dispute existed between Israel and South Africa, despite what Shaw called Israel's, quote, conciliatory and friendly offers to meet with South Africa to discuss its concerns about the Gaza war. This defies common sense, given that in November, Pretoria publicly accused Israel of genocide and called for the International Criminal Court to issue a warrant for Netanyahu's arrest. Israel responded by withdrawing its ambassador from South Africa. Shaw then addressed the voluminous statements made by Israeli officials introduced in court by South Africa as evidence of, quote, genocidal intent. Shaw dismissed these statements as, quote, random assertions that failed, quote, to demonstrate that Israel has or has had the intent to destroy the Palestinian people. He contended that none of those statements constituted an official policy of the Israeli government, and said the only relevant factor for the court to consider is whether such statements reflected official decisions or directives made by the Israeli leaders and its war cabinet. A good defense, I think. Shaw declared they did not, citing several official Israeli statements directing armed forces to comply with international laws and to make efforts to protect civilians from harm or death. He neglected to respond to the direct connections drawn, including through video evidence by South Africa's legal team, showing how Israeli forces on the ground echoed Israeli official statements about destroying Gaza as they laid siege to the Strip. So here's a real argument here, I think. Two different sides. This is a real controversy, I think could go either way. I mean, I'd like to hear more facts, but that's why it's important that the part of the declaration charges Israel with keeping all evidence that it has of possible genocide. Because later on, I think the damning evidence will be any official policies from Israel, from the IDF leadership or Israeli political leadership, saying, go and kill these people, you know, any genocidal documents or orders behind the scenes. Let's see. Yeah, there's a lot of stuff here. I don't want to go through this whole article by Jeremy Scahill. I want to see what this these other people said that we didn't watch their video. Galit Raujan, another Israeli lawyer, argued that Israel was operating within the rules of law in its attacks on Gaza. She spent considerable time accusing Hamas of using hospitals and other civilian sites to operate, militarily and to hold Israeli hostages. South Africa, she said, pretended, quote, as if Israel's operating in Gaza against no armed adversary, and said the civilian deaths and destruction caused by Israeli operations is, quote, the desired outcome Hamas wants. Many civilian deaths are caused by Hamas, she alleged. I mean, that works if Hamas is the one actually pulling the trigger. She repeated claims that have been debunked about Hamas using hospitals for military operations and holding hostages, claiming that any damage Israel had done to hospitals in Gaza was, quote, always as a direct result of Hamas's abhorrent method of warfare. Responding to South Africa's assertion that Palestinians were given just 24 hours to flee their homes and hospitals, Raujan claimed Israel had given the warnings weeks in advance through leaflets, online maps, and social media accounts. She did not mention that Israel has frequently shut down the internet in areas of Gaza and has repeatedly struck areas to which it told people to flee. I think those are important points that undermine what she's saying, but I'd like to see weeks in advance claims through leaflets and online maps. The leaflets. After describing what she characterizes Israel's extensive efforts to deliver aid to the people of Gaza, Raujan said it was evidence that the charge of genocide is, quote, frankly untenable. She said she had only told the court of a, quote, mere fraction of the efforts Israel had made to warn civilians to leave their homes and to deliver aid, but that it was, quote, enough to demonstrate that the allegation of the intent to commit genocide is baseless. Her portrayal of Israel as a beneficent humanitarian moving mountains to alleviate the suffering Palestinians would be laughable if it wasn't so deadly. But such statements are easy to offer when your official policy is to portray aid organizations and UN workers as Hamas operatives. I think this is an argument from Israel against the weight of evidence, or, having contradictory evidence, but I think it is an argument as to the weight of evidence, and it's a legitimate argument to make if they can establish those facts, which we'll see if they can. For months, international aid organizations have condemned Israel, which functions as the overlord of what goes in and out of Gaza, for obstructing humanitarian aid deliveries into Gaza. Just this week, UN officials said that Israel is blocking it from getting aid to northern Gaza, while the World Health Organization said it is facing insurmountable challenges in delivering aid. Nonetheless, Omri Sender, another lawyer for Israel, claimed that Israel is delivering large quantities of aid daily to Gaza, despite Hamas consistently stealing it. He told the judges that, quote, Israel no doubt meets the legal test of concrete measures aimed specifically at ensuring the rights of the Palestinians in Gaza to exist. Now, again, there's going to be more briefing and more evidence heard. They close by saying that if South Africa is trying to force a unilateral ceasefire by Israel, which means they're trying to stop Israel, but Hamas won't listen, regardless of what happens in the court, it would allow Hamas free fire, basically. And that's what Israel's intent is to do. I think that's not believable. I think you lose your credibility by Israel as making some of these claims. I think, and that's the end of the Jeremy Scahill article that I'm going to cover, but I think that in some sense, Israel kind of loses some of their credibility by making outlandish claims, such as South Africa is using the power of the court as a sword to attack Israel. I think it makes perfect sense why South Africa is the country that is prosecuting this case against Israel. I mean, if you listen to South Africa's opening remarks, they are made by two Black African attorneys, and they specifically, that's not them here, I'm trying to bring them up. They specifically reference South Africa's checkered history.
To self-determination.
This gentleman here discusses the history of South African apartheid and how, their history and victimhood makes them an ideal country now, after having corrected those wrongs, to prosecute this case. And they talk about colonialism and the history of colonialism, and obviously the elephant in the room of Israel being a colonialist power displacing the Palestinians. So these two gentlemen here, this gentleman particularly sharply dressed, might I add. I like it. It's tasteful and it looks snazzy. But there is a whole thing going on in the background here that I could talk about for a long time, of, specifically some arguments being lobbed at some of my colleagues by other libertarians who are pro-Israel, that you, I don't know, might have seen on the internet, particular figure, that essentially libertarians suffer from a framing bias when it comes to supporting Israel, that we're all just secret leftists, that we're buying into this leftist, sorry, this leftist narrative of fighting back against colonialism, and that, no one now is advocating that the United States give up large parts of its territory back to Native Americans or back to the Mexicans or what have you. Kind of, in a sense, ignoring the fact that, well, I don't necessarily like or appreciate the leftist anti-colonialist undertones. I think it's problematic. I mean, I'm clearly on the side of displaced Palestinians and their struggle against, the West and the power of the West, and that problematic history, if you would say, of aggression, of institutionalized aggression against the property rights of Native people. But I think framing it in the collective leftist kind of like fighting colonialist powers and the oppressor versus the oppressed lens, and how they use that for everything, right? I don't think it's the proper framing, as libertarians and Sheldon Richman put forward in Coming to Palestine. It is, in simply libertarian terms, you should be pro-Palestinian, and who has the legitimate right to the land is the operant question. And that's what I covered in, my episode, How Israel Became Palestine, to bring it full circle, talking about that question and going through that article about going through the legal claims to the property, I think is the most important thing. But I think where this departs from other cases that we shouldn't be on board of which would be like, now should we have reparations, or now should we be taking land from United States landowners and giving it back to the people that were dispossessed by conquest in the American expansion. For that, I think we need to take a time machine and go back, 200 years. And I think any self-respecting libertarian right now, if we were transported back in time, or we were existing at the time, would be against the violent dispossession of Native people by the United States of their land, in wars of conquest and wars against Native American groups. I think any libertarian should have been against that at the time. Again, you're correcting for, managing your expectations of what actual opinion would have been at the time. Like, it's one thing to say you're an abolitionist now, but would you have been an abolitionist in 1860? That's the question, right? But I think our opinion now is that it was sins for the U.S. state. It was sinful and aggressive and not supportable for the United States to do that. But all of the parties to that conflict are now dead several generations. So it's, of course, we're not advocating that people who grew up now on dispossessed land be forced to return that land to an unidentifiable ancestor. Is just absurd. And the difference being is that there are Palestinians now living who are identifiable, who had identifiable pieces of property seized from them in a lineage that is identifiable and traceable, and that doesn't go back 150 years into antiquity in a legal sense. And furthermore, the United States doesn't, comparing the situation that currently exists in Israel, you can't compare it in any meaningful sense to a situation where, like, a comparable to the United States Native American versus Native Americans or versus the Mexicans displaced in the 1800s, right? Because in Israel there is Palestinians, throughout the Gaza Strip who are currently living in a prison camp, a situation where they're geographically limited on where they can go. They don't have the same rights. They are essentially captive citizens in a situation that they can't leave in a besieged block of their own land. And that is very different from a situation, and this is currently happening, whereas in the past, the comparison is, maybe it would be that we indefinitely keep Native Americans, deprive them of their rights, dispossess them of their land, keep them confined in a small geographical area where you are constantly going in through war parties and killing them indiscriminately. And just because those situations aren't comparable, because we're looking at that situation in hindsight, and we wouldn't do anything to alleviate or to have reparations or restitution for that situation because it happened in such an ancient past. Like the notion that, well, you wouldn't do anything about Native Americans being dispossessed then, you wouldn't do anything now, and you'd be against the leftists who try and do anything about that now, doesn't mean that we can't oppose that having happened then and oppose Palestinians being subjected to that treatment in modern times with our tax dollars that we can actually do something about. And the suggestion, I just don't think that it has any merit as a comparator to be like, you should be pro-Israeli because you don't oppose, or I think the argument goes that you should be pro-Israeli because you would oppose people who want reparations for Native Americans for being dispossessed of their land in the ancient past, right? Or Mexicans because we took their land by conquest or something like that. Is just absurd to the point of not being relevant at all in any sense. So, okay, well, it's been about 2 hours and 15 minutes. I think I should be given this long episode because I hope that this was immensely beneficial to you in understanding what's going on and in reviewing what was said in the arguments. We'll anticipate an actual ruling on this in a future episode. And thanks for sticking with me. I apologize for the long hiatus, and things are difficult, and I got, a lot of responsibilities on my plate. And I just appreciate your patience. And with all those responsibilities, it's not always easy to have the time and motivation and attention and energy to be putting content out super regularly because you can see that, today's a Monday afternoon. It's MLK Day, so the courts are closed, and I am here doing an episode because it's the only time I really have to do it. So, all right. libertarianinstitute.org, vitaldissent.com. Again, show notes, vitaldissent.com/266, and we will catch you next time. Peace.